We were all looking at the Supreme Court's decision on presidential immunity last week. Due to the immunity opinion in Trump's favor, the sentencing for his 34 insane convictions has been delayed until September. That was the big news last week. Well, SCOTUS passed down another opinion last week which is just as important as immunity, but nobody is talking about it. The recent Supreme Court opinion on Loper Bright Enterprises v. Raimondo effectively overturned the Chevron Doctrine, which is a principle derived from the 1984 U.S. Supreme Court case, Chevron USA, Inc. versus the Natural Resources Defense Council, Inc. The Chevron Doctrine directed courts to defer to a federal agency's interpretation of ambiguous laws that the agency administers. Why does this matter to us, you might ask? If you've ever read FDA laws related to energy medicine, you'd know that the law couldn't be more confusing. The medbeds of the future clearly fall under the category of energy medicine. The best clarification of the regulatory enforcement for energy healing was issued in a February 2007 guidance document published by the FDA. The guidance document concludes that various CAM therapy or practices may be subject to regulation. Such language really does little to clarify energy devices, and it was produced by the agency making this guidance moot now. Had the Chevron Doctrine not been contradicted, officials of the FDA would have had the authority to interpret the law in a way that could stop the use of the medbeds of the future. Now, before you repeat the narrative that the military is in charge of medbeds and all current laws are just going to dissolve, you must realize that while the military might initially oversee the use of the beds, they do not have the authority to violate, change, or interpret FDA law. The SCOTUS decision just removed the FDA's ability to unilaterally decide that medbeds must complete a new medical device application and go through the approval process. If the FDA does attempt to impede the distribution of medbeds, they can't do it without a decree by the courts, effectively making it much harder for the FDA to stop the medbeds. So, previously, federal agencies were able to interpret ambiguous statutes. The agencies are no longer able to make such regulatory decisions without due process. This significantly impacts the regulatory landscape because the ruling shifts the power to interpret laws back to the judiciary, limiting agencies' power in implementing complex and technical regulations. Without Chevron deference, courts will no longer defer to agencies' expertise in interpreting ambiguous laws. Opponents of the decision say that this decision could lead to increased legal uncertainty and challenges to regulatory actions. They believe that future technological advancements may face hurdles as judges, rather than specialized agencies, will decide on regulatory interpretations. But the reality is that the regulatory agencies no longer have such all-encompassing power over energy healing due to the lack of clarity in. So now the game has changed, and the FDA's wings have been clipped, so to speak. Why should you care? Well, think about cutting-edge medical tech like off-world med beds. These futuristic devices promise to revolutionize healthcare, but without the Chevron Doctrine, the path to innovation is no longer impacted by agency interpretation. So, tech innovators, buckle up. The landscape of medical innovation and regulation appears to be changing. The National Center for Complementary and Alternative Medicine within the National Institute of Health has classified energy therapies as a category known as CAM, or Complementary and Alternative Medicine. The SCOTUS ruling emphasized that it is the role of the judiciary, not agencies, to interpret the law, especially when the statutory language is unclear. So the bottom line is that FDA will no longer have the power to march in and shut down medbed centers in the United States without due process. It's the little things that sometimes make the difference, and there are a lot of little things going on in the background. I wouldn't be surprised if a clarification of energy medicine occurs in law, and I'll be watching for that. So things are looking up, and hopefully we will be stepping into a whole new landscape of healing in the very near future. Until next time, keep the faith and share with others who are losing hope.